for the administrative state and look for ways that we can reform the regulatory and administrative law to work better for everyday Americans. It's no secret that regulatory burdens have reached an all-time high. Regulatory agencies create rules with the force and effect of law. And the number of rules that agencies create is overwhelming. In the final year of the Biden-Harris administration, unelected bureaucrats finalized over 3,000 rules. It's an average of 8 regulations per day. By contrast, during the same period, Congress passed almost 150 laws. In other words, the executive branch issued mandates with the force of law over 20 times more often than the legislative branch. According to the Competitive Enterprise Institute, these regulations impose a total estimated annual cost of $2.1 trillion or more than $15,000 per American household. Some of my colleagues on the other side may claim that because Congress cannot pass laws, agencies feel empowered to take over. Congress was designed to require lawmakers to think deeply about these decisions. Congress was also designed to be accountable to the voters. If our constituents do not like our decisions, then we are voted out of office. Unelected bureaucrats, by contrast, are not politically accountable. This lack of accountability shows. When agencies make these rules, they not only act as a legislator for the country, but often as prosecutors and judges through the administrative process. Agencies often bring enforcement actions in their in-house administrative courts. The same agency that makes the rules also decides to sue if a person broke them. Then, to prove that a person broke the rule, the agency tries the case before its own in-house judge. In so-called, quote-unquote, independent agencies, commissioners who directly prosecute the case also act as judges on appeal. The whole system defies logic at this point. The administrative system is set up to regulate the American people into submission, which is entirely at odds with the principles that this country was founded on. Our founders deliberately split the making of laws, enforcement of laws, and judgment of laws into 3 co-equal branches of government. Our founders were convinced and concerned about exactly the same centralized power we now see in the administrative state. It does not have to be this way. Last Congress, the Judiciary Committee marked up numerous bills aimed at reforming the administrative state: the REINS Act, the Midnight Rules Relief Act, the Prove It Act, the Separation of Powers Restoration Act, and the One Agency Act, just to name a few. All these bills were aimed squarely at the topic we are here to talk about today: reining in the administrative state. I'm proud of the work this committee undertook last Congress, and I hope for the sake of the American people that we turn these proposals into law this Congress. My colleagues on the other side of the aisle routinely oppose all attempts by Congress to rein in the administrative state. They also criticize President Trump for taking steps to control the administrative state. They ignore that the Constitution makes the president the leader of the executive branch. They will do everything in their power to protect the unelected bureaucrats in the administrative state. Why? Because these unaccountable bureaucrats do the bidding of my colleagues in the minority. This is true even though Americans rejected their views in the most recent election. Today, we have an opportunity to hear from witnesses who have deep experience in the regulatory reform area. Ms. Wad and Mr. Smith are entrepreneurs and deal with the crushing weight of regulations every day. Mr. Smith has even faced the administrative court system and was forced to pursue a case all the way to the Supreme Court to vindicate his constitutional rights. Dr. McLaughlin is an expert in regulatory and economic analysis and has written extensively on how damaging regulatory burdens are on the economy. These witnesses are perfectly prepared to supply members of the committee with the required information to better inform us as we work on possible solutions and consider the proposals that have already been introduced. I want to thank the witnesses for appearing before us today and look forward to hearing what each of you has to say on the topic. I now recognize the ranking member, Mr. Nadler, for his opening statement.
Thank you, Mr. Chairman. Mr. Chairman, holding a hearing today on, quote, reining in the administrative state is a bit like rearranging the deck chairs on the Titanic. As we speak, Elon Musk and his band of near teenage accomplices are systematically working their way through the executive branch, knocking down agency after agency, while undermining the rule of law and shredding the Constitution along the way. Musk and his team have unprecedented access to our most sensitive and personal data. They have gained access to extremely sensitive tax information at the IRS, highly restricted government records on millions of federal employees and their families from the Office of Personnel Management, and personal data related to health insurance plans, workplace safety and health investigations, child labor, and more from the Department of Labor. And this is just what we have learned through news articles, because all of these actions have been taken without any transparency to the American people. Musk and his team have accessed at least 18 agencies and untold amounts of sensitive data that is attractive to bad actors here and abroad. But Musk and his assistants are not just accessing this data. They are feeding it into AI models, downloading it onto commercial servers, and possibly taking it off premises. Because Musk and his team can also change our government systems. Not only is the personal information of millions of Americans at risk, but also the systems that ensure our safety and core government functions. For example, Musk and his team have accessed core systems at the Federal Aviation Administration. Experts have warned that, quote, even a small system disruption could cause mass grounding of flights, a halt in global shipping, or worse, downed planes. Officials at the FAA warn that going into these systems without an in-depth understanding could result in death and an economic harm to our nation. Nevertheless, Musk indicated that the DOGE team will aim to make, quote, rapid safety upgrades to the air traffic control system. Just in the past few weeks, we have seen what happens when mistakes are made in our air traffic control system, when a Black Hawk helicopter ran into a commercial flight, resulting in dozens of deaths. Musk and his team are opening us up to more deaths and critical economic harm. But Elon Musk is not content just to cause massive disruption and expose us to greater risk. No, he is also using his unfettered access to our agencies and our data to benefit himself. For example, the Department of Labor was investigating workplace abuse allegations at 3 Musk-owned companies: the Boring Company, SpaceX, and Tesla. So, Musk and his team invaded the agency and gained access to their information on current and past investigations. Just days before they got access to the Consumer Financial Protection Bureau, Musk finalized a deal with Visa to process peer-to-peer payments for a wallet feature on X. Because the CFPB polices such payment systems, the data Musk and his team accessed could give his new X wallet feature a competitive advantage in the market. And as a kicker, the Trump administration instructed the CFPB to halt its work, thus ensuring that there's no one to keep Musk's new payment system from exposing personal data or enabling fraud. Never mind that the CFPB has produced almost $20 billion in consumer relief and has put millions back in the pockets of Americans. The agency had information Musk needed, so he got it. The agency would have enforced the law with a likely impact on his wallet, so the agency's work was halted instead. Serious concerns have been raised about whether the people accessing this data, many of them barely past college, have the appropriate training and vetting necessary to handle such sensitive data. That is an active data breach on a scale we have never experienced before, but this time the threat is coming from inside the House. Imagine what domestic criminals or foreign adversaries could do if they got their hands on this information. This is a clear and present danger, and yet our Republican colleagues do nothing. In addition to these structural attacks on the executive branch, the Trump administration is also reclassifying civil servants as political employees who can be replaced with flunkies beholden to Donald Trump, imposing loyalty tests on national security officials and encouraging tens of thousands of employees to resign, with promises it has no authority to make. As a result, it is hollowing out the workforce and the decades of experience and technical expertise that comes with it. Without any authorization from Congress, the Trump administration has also taken several other actions that have thrown the federal government into chaos. It attempted to impose a, quote, temporary funding freeze, unquote, across much of the federal government that a judge has already ruled unlawful. It fired duly appointed Democratic members of independent agencies to deprive these agencies of a working quorum and essentially prevent them from fulfilling their missions. And to ensure that no one is able to hold the administration accountable from within the executive branch, the President fired more than a dozen inspectors general without following the statutory requirements for doing so. These actions are as unconstitutional as they are dangerous. While we witness these incursions on the rule of law and the Constitution, my Republican colleagues do nothing. In fact, they cheer on Elon Musk as he usurps congressional authority and arrogates unprecedented power to himself. When Joe Biden was president, we heard stirring speeches from our Republican friends about the need to assert our Article I authority. We were told that the Biden administration was guilty of dangerous overreach when it attempted to help people drowning in student loans, or protected our communities from gun violence, or helped shield consumers from corporate abuse. But now that is ancient history. Now they aid and abet shadow President Musk while he bulldozes his way through the administrative state, untethered to any congressional statute or authorization. There is no check and no balance from the Republican Congress, just feckless inaction because it serves their purposes. They know that undermining the critical protections provided by our agencies would be deeply unpopular, so they are content to abdicate their responsibilities and let Elon Musk do their dirty work. I urge my Republican colleagues to stand up for this institution and for the people they represent. I yield back.
Gentleman yields back. I now recognize Chairman of the full committee, Mr. Jordan, for his opening statement.
Thank you, Mr. Chairman. Instead of stopping the stupid spending, Democrats attack the guy who's exposing it. I think the taxpayers of this country would just as soon we stop spending their money on dumb things. Like what was the example from USAID, some transgender comic in Ireland spending money on Bert and Ernie and Big Bird on Baghdad TV. I think they would prefer we not do that. Elon Musk is exposing in the federal government exactly what he exposed at Twitter when he purchased Twitter. What did we find out there? Big government was pressuring big tech to censor Americans. And you don't have to take my word for it. We had the Twitter files. Oh, and we also had someone else in big tech send a letter to this committee and tell us exactly what they were doing. Mark Zuckerberg said the Biden administration was pressuring us to censor. We did it. We're sorry. We won't do it again. Told the whole world that in a letter to this committee. So Elon Musk is now doing that for the federal government. We think that's a good thing. And to understand the fundamental difference the left has with us conservatives. Democrats believe it is the career elected bureaucrats who are supposed to run the country. We don't think that's the way it's supposed to work. We actually think it's the people who put their name on a ballot who get elected by we the people who make the decisions. And the guy who got 77 million votes on November 5th says he wants Elon Musk working for him, the elected member who heads the executive branch working for him, every bit as much as the federal employees, the people in Treasury who are supposed to have all the answers, or in USAID who be the career officials, working for him to expose stupid things our government is spending money on. And the Democrats are going to attack that guy? Go ahead. Go right ahead. But we know the real consequences of having this administrative state, these bureaucrats run things. We got two witnesses here who've lived it. Ms. Wade and Mr. Smith. They're here to tell about how that had impacted their business. So I appreciate the chairman having this hearing. This is exactly the kind of hearing we have to have. And I appreciate the work the president and his team are doing to expose the stupid things bureaucrats spend the hard-earned money of the people we get the privilege of representing. I yield back.
Gentleman yields back. Now recognize the ranking member of the full committee, Mr. Raskin, for his opening statement.
Thank you very much, Mr. Chairman, and thank you to the ranking member of the subcommittee, Mr. Nadler, and thank you to my colleague, Chairman Jordan, and thanks to all of our witnesses for being here with us today. I was surprised to hear my friend from Ohio talking about a transgender comic book from I can't remember which country, but If there's a form of government expenditure taking place that we have a problem with, isn't that why the congressional oversight function exists? Don't we have a whole oversight committee, which you serve on, which I've served on, which can do that? Do we really need to hire a fourth branch of government called Elon Musk to go out and do it for us? We're about to enter into a budget process right now. We can deal with it ourselves. Mr. Chairman, the last 22 days, Donald Trump's billionaire government has taken a wrecking ball to public institutions and the rule of law in America. The agent of chaos is Elon Musk, a, quote, special government employee purportedly working on technological reform. More crucially, he's a big businessman whose floundering Tesla sales in Europe create huge financial pressures for him, according to the business press. Even more crucially, he's a government contractor who collects billions of federal taxpayer dollars every single year and yet has not filed a single employee ethics disclosure form as required by law. He has access not only to computers controlling his own billion-dollar payments from us, the people, but to computers containing his contractor rivals' contract bids, their contracts, their invoices, and their payment systems. Yet he has not shown us a single conflict of interest waiver form for these multiple egregious apparent conflicts of interest. He and his mutant teenage racist computer hackers have taken possession of financial payment systems at the United States Department of Treasury, meaning data access to the private financial records of every American citizen, every member of Congress, every federal prosecutor, every regulator who's supposed to be looking at what his business does, every private lawyer and every federal judge who they're now calling for the impeachment of because they dare to speak up for the rule of law. What could go wrong with this situation? Fortunately, we do still have an Article 3, a working federal judiciary, which has issued no fewer than 12 injunctions in 3 weeks. 12 temporary restraining orders or preliminary injunctions in 3 weeks against the illegality of this arrangement, including an injunction against any further unlawful seizure, possession, and corruption of Americans' private financial data. Now, the Elon Musk cyber raid against our data and privacy infrastructure has set the stage for the administration's outrageous and unprecedented violation of congressional lawmaking and spending power. That's what the first hearing of this subcommittee should be about, Mr. Chairman, the blatantly illegal and quickly reversed freeze on billions of dollars in federal grants already appropriated by the United States Congress, programmed by the agencies, contracted for by government lawyers, and in the proper pipeline for payment. The flagrantly illegal efforts to not pay federal workers and honor our contracts for work already rendered, to condition federal funds on totally made-up restrictions never voted on, much less approved by Congress, and the scandalous effort to dismantle and neutralize entire federal agencies like NOAA, USAID, and the CFPB, spitting in the face of congressional power enactments and appropriations. An Appropriations Act is a federal law, like any other law. Like the law, for example, against violently assaulting federal police officers. An Appropriations Act is not a recommendation or a bargaining maneuver with the executive branch. It is a law. It must be enforced. This administration needs a constitutional refresher course, Mr. Chairman. The preamble to the Constitution says, we the people, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and preserve to ourselves and our posterity the blessings of liberty, do hereby ordain and establish the Constitution of these United States. And the very next sentence of the Constitution establishes in Article 1 the Congress of the United States possessing all of the legislative power. Some of my colleagues have taken to saying we're three co-equal branches. I beg to differ We're not three co-equal branches. Not at all. First of all, co-equal is not even a word, right? That's like extremely unique. It doesn't mean anything. So they're saying three equal branches. I don't think so. Read James Madison, the Federalist Papers. Congress is the predominant branch. Congress is the lawmaking branch. It's Congress. Check out Article 1, Section 8. All of the powers we have to regulate commerce domestically and internationally, to pass the budget, to appropriate money. Congress does that, and then Article 1, Section 8, Clause 18, and all other powers necessary and proper to the execution of the foregoing powers. And after all of that, you get to 4 short paragraphs in Article 2. My friend Mr. Jordan has been quoting the first sentence all over TV. He thinks that he somehow has a knockout argument. He says, the executive power shall be vested in a president of the United States of America. Yes, indeed, Mr. Jordan, that's where the executive power is vested. But what is the executive power? The core responsibility of the president of the United States is to take care that the laws are faithfully executed, right? Not defied, not violated, not trashed, not rewritten, to take care that the laws are faithfully executed, which is precisely what's not happening today. As they say, oh, well, Elon Musk, he's got all the power of the president. Donald Trump himself could not be doing what Elon Musk is doing in Washington today. He can't evaporate AID. He can't nullify the CFPB. He can't destroy an agency set up by us on a bipartisan basis in Congress. Nobody in the executive branch has that. Yeah, the president is on top of the executive branch, but we're the lawmaking power. And who sorts out the conflict if there's a conflict? The courts do. And what have the courts been saying? They've said a dozen times in 3 weeks that they're violating the Constitution of the United States and the laws passed by Congress. That's what's going on in America today. That's what we should be having a hearing about, not some airy academic conversation about the administrative state, whatever they mean by that. I yield back, Mr. Chairman.
Gentleman yields back. Without objection, all the opening statements will be included in the record. We'll now introduce today's witnesses. Dr. Patrick McLaughlin. Dr. McLaughlin is a research fellow at the Hoover Institution at Stanford University and a visiting research fellow at the Pacific Legal Foundation. He authored more than 30 peer-reviewed studies on a variety of topics, including regulatory economics, administrative law, and international trade. Mr. Patrick Smith. Mr. Smith is the Chief Executive Officer and founder of Axon Enterprise. Axon offers a variety of products and services, mostly to law enforcement and public safety entities. These products and services include taser devices, body cameras, de-escalation training, and evidence management and reporting software. Ms. Mugat Wad. Ms. Wad is the co-founder and Prospera Africa, a governance platform for special economic zones, and a senior fellow at the Atlas Network, an organization of African free market think tanks. She was named by Forbes as being one of the 20 youngest power women in Africa. Did I get that right? A young global leader by the World Economic Forum, and is a TED Global Africa Fellow. Professor Stephen Vladeck. Mr. Vladeck is the Agnes Williams Sesquicentennial Professor of Federal Courts at the Georgetown University Law Center. Professor Vladeck focuses on federal courts, the Supreme Court, national security law, and military justice. We welcome our witnesses and thank them for appearing today. We will begin by swearing you in. Would you please rise and raise your right hand? Do you swear or affirm under penalty of perjury that the testimony you are about to give is true and correct to the best of your knowledge, information, and belief, so help you God? Let the record reflect that the witnesses have answered in the affirmative. Thank you. Please be seated. And please know that your written testimony will be entered into the record in its entirety. Accordingly, we ask that you summarize your testimony in 5 minutes. Dr. McLaughlin, you may begin. Microphone, sir. Thank you.
Thank you. Chairman Fitzgerald, Ranking Member Nadler, and members of the committee, thank you for the opportunity to testify today. My name is Patrick McLaughlin, and I am a research fellow with the Hoover Institution and a visiting research fellow with the Pacific Legal Foundation. I appreciate the chance to discuss how regulatory reform can promote economic growth, encourage innovation, and reduce unnecessary burdens on businesses and consumers. Let's begin by acknowledging that regulations can play an essential role in achieving policy objectives such as protecting public health and the environment. But when regulations pile up over time without systematic review, this regulatory accumulation has costly consequences. Compliance becomes more complex, businesses face mounting overhead costs, and entrepreneurs struggle to navigate the maze of over 1 million regulatory restrictions that are currently on the books. Projects like the Reg Data Project, which uses AI to quantify various aspects of regulation and makes the data publicly available, have permitted economists to study the effects of regulatory accumulation and its counterpart, deregulation. And I'd like to review some of those findings today. First, I want to emphasize the magnitude of the economic effects of regulatory accumulation, or the other side of the same coin, deregulation. In my written testimony, I cited a study that I co-authored, published in 2020 in the Economics Journal Review of Economic Dynamics. That study found that regulatory accumulation, the buildup of rules over time, distorts business investments, expenditures on things like research and development, new machinery, and new buildings. These are the same activities that, in the long run, tend to increase productivity and drive economic growth. We found that on average, federal regulatory accumulation slowed overall GDP growth by 0.8 of a percentage point. Considering GDP growth is, in the US, typically 2 to 3% annually, losing nearly 1 percentage point represents a massive loss. Other studies have found even larger effects. Second, I want to highlight the regressive effects of regulatory accumulation. Higher levels of regulation are associated with increased levels of poverty and income inequality. Specifically, a 10% increase in federal regulations is associated with a 2.5% increase in the poverty rate and a 4% increase in income inequality. When you dig a little deeper, it's easier to understand why. Regulations affect households directly in many ways, even when those regulations are targeted at businesses. For example, regulations typically increase the production cost of goods, and some of those costs are, of course, passed on to the consumer in the form of higher prices. One study found that a 10% increase in total regulation leads to a nearly 1% increase in consumer prices. Furthermore, the study found that the effects of those price increases are regressive. That is, the poorest income groups experience the highest proportional increases in the prices they pay. Regulations also affect households by diminishing their economic opportunities. Multiple studies have found that higher levels of regulation are associated with fewer total firms and lower levels of employment. Finally, despite the fact that I'm an economist, I want to offer a positive message. We have seen that these negative effects caused by regulatory accumulation can be reversed. Several states and provinces of Canada have already begun the hard work of reassessing existing regulations to see which ones truly benefit the public versus which ones are outdated, redundant, or impose costs that can't be justified by the benefits. By identifying and removing regulations that no longer serve their intended purpose, we can free up resources for more productive uses. Deregulatory efforts seem particularly effective when coupled with tools like regulatory budgeting or sunsetting. The province of British Columbia, along with several other states, have experimented with tools like this. And in British Columbia, they were one of the first jurisdictions to use regulatory budgeting to deregulate. And they cut 40% of regulations in a 3-year period. And then they capped future regulatory growth with a one-in, one-out type regulatory budget. The result was a sustained boost to economic growth. A recent study found that the province's growth rate increased by just over 1 percentage point because of the deregulatory efforts. In closing, deregulation has the potential to invigorate the economy, spur innovation, and lessen the disproportionate burdens placed on smaller firms and vulnerable populations. Thank you, and I look forward to answering any questions you may have.
Thank you, Dr. McLaughlin. Mr. Smith, you may begin.
Thank you, Chairman Fitzgerald, Ranking Member Nadler, and the entire subcommittee for having me here today. It's an honor. My name is Rick Smith. I am the CEO and founder of a company called Axon. We're an American company in Arizona that employs over 4,000 people today. I appreciate the opportunity to testify because the unchecked power of the government led to serious consequences for my company, for my employees, and deeply for me personally. No bureaucracy can be allowed to act as prosecutor, judge, and jury without checks and balances and oversight. Many fine Americans work at the FTC with the best of intentions. Yet, the agency wields unchecked powers in ways that can crush innovation, stifle economic growth, and deny basic constitutional rights. This overreach was not the intention of our founders. The work of this committee is critical to ensuring that all Americans do receive the due process protections they deserve and are guaranteed under the Constitution. I started Axon over 30 years ago in a garage with a dream to bring Captain Kirk's phaser to life, to provide a real alternative to deadly force. We can do better than bullets. When I first introduced taser technology, people laughed at the idea. No one thought they would work, except my dad. He put in his life savings. I nearly wiped him out. At the edge of losing everything, after 7 long years, we finally turned the corner. And today, you see our yellow taser devices on almost every police officer in America. They've been deployed millions of times, and together with the body-worn cameras, another technology that we invented, they're used across the globe, from the London Met to Sydney, Australia. I've challenged my team to go further. We've published a public moonshot goal to cut gun deaths in policing 50% over a 10-year period. We believe we can do this through more effective, less lethal alternatives and changing police through more advanced VR training. These aspirations and our mission were severely disrupted when we came up against the unfettered power of the FTC. In May of 2018, we acquired a small, failing body camera competitor that was losing $1 million a month. Competitor after competitor passed on this deal. For 18 months, they tried to sell the company. We were the buyer of last resort. And we bought this money-losing company because it saved critical public safety agencies, including the NYPD, from serious disruptions if their body camera programs were allowed to fail. The $13 million price we paid was well below the legal threshold for FTC review. What followed was months of requests for information, mountains of legal filings, and a growing sense of disbelief that this money-losing deal had drawn such a disproportionate government response. We offered to write off our entire investment. In fact, we offered to put another $13 million in cash, effectively doubling our losses. Shockingly, we were told this was not enough. The FTC demanded that we also hand over our most valuable assets. First, license all of our intellectual property, creating a full clone competitor. Then to hand over our most valuable customers to be chosen by the FTC. And most alarmingly, we were asked to write a blank check. This was such an outrageous request, our lawyers said, hold on, did you say blank check? And the government said, yes, you heard us correctly. You will write a blank check. You will fund this new competitor until we tell you you are done. I learned that over the previous 20 years, the FTC had won 100% of cases in its in-house forum. Over our dinner table at home, I shared this terrifying situation with my family. And my elementary school twins said, hey, Dad, we're learning about the Constitution and the Declaration of Independence. The colonists said the courts back then were beholden to the king. And so they set up a new country with a constitution where the courts must be independent. This is unconstitutional. You should sue them. From the mouths of babes, I was like, wow, this is so clear and obvious. That is what we must do. And so we preemptively sued the FTC in federal court, challenging their constitutionality and saying, hey, just sue us here where we've got a shot to tell our story. In April 2023, after 4 years of disruptions to our business, the Supreme Court ruled unanimously 9-0 in our favor, allowing our challenges to proceed in federal court. In response, the FTC dismissed its complaint against us rather than defend its outrageous actions and demands against us in front of an impartial federal judge. As our 9-0 decision in the Supreme Court demonstrates, this is bigger than one company or one case. Every American, whether an individual, small or large corporation, should have the right to a fair trial before an independent judge, before the government can strip them of their livelihood, their property, or their rights. It's a bedrock principle of justice. Thank you for your time, and I look forward to answering your questions.
Thank you, Mr. Smith. Ms. Wad, you can begin now.
Good morning, and thank you, Mr. Chairman, for having me, distinguished members of the... Sorry, can you hear me now? All right, good. Thank you again, Mr. Chairman, for having me here, and for the distinguished members of the committee for this opportunity to testify today. This matter is a personal matter to me, and I will explain why. My name is Magatte Wade. I'm a Senegalese-American entrepreneur. I've been living in the US since 1998, and I became a US citizen in 2018. I'm also an author of The Heart of a Cheetah, a book that talks about African entrepreneurship and prosperity. It has been endorsed by Nobel laureate like Vernon Smith, development economist as Bill Easterly, and Whole Foods founder John Mackey. I am a co-founder of Prosper Africa, an initiative that is out there to create something similar to what you guys would call here the Freedom Cities in America. And I have been doing business, obviously, both in Africa as in the US, in the states of California, Texas, and New York. Mr. Raskin, your words earlier really, really worried me, and I will tell you why. When you say we are here, and we should be here to talk about Mr. Elon Musk and all the unconstitutional things that he's doing, and you said we shouldn't be here to talk about regulation or anything like that, first of all, I want to say, then why did you have me here? As an entrepreneur, my time is valuable. I came here because I thought we were going to talk about the regulatory state and why it matters. So you need to make up your mind on that. And I'm deeply offended by what you said there. And furthermore, I would tell you why I came when I was invited to speak on this. Because right now, everybody in this country, these issues of regulation, overregulation, has been made into a matter of partisanship. Are you from the left or are you from the right? I don't care. Because where I come from, the overregulation causes us to be where we are. My continent, Africa, is the poorest region in the world today because it happens to be the most overregulated region in the world. So if you don't see the value of overregulation, if you need and want to wait until this country becomes like most African countries, I don't know. I love this country and I don't want to see it go down there. So, and also, just so you know, what does overregulation mean for regular people? It means death, literally. People are packing themselves into little fishermen's boats, trying to leave nations that are overregulated, therefore no jobs, and then they have to leave and go seek jobs someplace else. By the way, English is only my fourth language, so when I trip on words, please excuse me, you all. So as a consequence of this perspective of mine, I'm aware of the fact that even in the US, it is difficult for a business person to be fully compliant with all the laws. In Senegal, I usually have to pay lawyers to make sure that I'm compliant all the way. It costs a lot of money and a lot of time and makes me very non-competitive. Everything I do it for the sake of African prosperity. And there is no sense in which anyone can call me a greedy business person. And yet most of us are subject to the potential of punitive power of the public officials. And as an African immigrant, I'm very familiar with the many informal small businesses that are run by other Africans in the US. Of course, the biggest one of them, for me at least, is occupational license. You see this hair of mine, the lady who breeds it. Most of the time it's going to be an immigrant lady who got here. She's not doing anything criminal or anything like that, but her business is going to be illegal because of all the laws and the licenses she has to get in order to do this, something that she learned to do since she was 12 back home. And here she is here sustaining herself, not touching the wealth or anything like that. This is paying her bills and the bills of her children and the people that she had left home. So then what? Are we people that should be penalized? Should those people be penalized? I don't think so. To take a different issue, Austin, where I live right now, the housing prices were rapidly rising due to excessive land use regulations until recently. Last year, I testified for the Texans for Reasonable Solutions to deregulate land use regulations, and they've made really great progress in reducing the growth in housing costs. We estimate that there is between 30 to 40% of the housing costs that are due to excessive regulations in some areas. When I moved to the US, I lived in San Francisco. I loved that city, yet I can't live in that city anymore for what that city has become, and it primarily has to do with the high cost of housing due to the regulations. Take another example. My husband is an education entrepreneur who was a leader in the micro school space before it became a thing. If you want a new renaissance in education, you need to minimize the regulations pertaining to new school creation so smaller education entrepreneurs can also get in the game and challenge the status quo. I ask again, do we really want to be penalizing these entrepreneurial educators?
Ms. Wad, your
yes.
time is
I'm
expired. We're going to have some follow-up questions, obviously, though. But thank you very much.
Thank you.
Professor Vladeck, you're recognized for 5 minutes.
Thank you, Mr. Chairman. Thank you for the opportunity to testify this morning. I must confess to at least a modicum of surprise that of all the topics for this subcommittee to investigate at this moment in American history, it has picked this one. Certainly, we can all agree that one of Congress's and this committee's most important constitutional functions is holding the executive branch to account. I would thus happily celebrate, if not affirmatively endorse, well-conceived efforts to rein in the executive branch, especially in response to specific abuses of existing statutory and constitutional arrangements, perhaps like the ones summarized by my fellow witnesses. But given what has transpired over the first 3 weeks of the new administration, a hearing focused on the proposed legislation being discussed this morning, and not on what is happening across this city and across this country, as we sit here today, strikes me as far more than just a missed opportunity. Indeed, if this committee was genuinely interested in reining in abuses by the executive branch, it strikes me that there are at least 4 distinct and far more pressing areas to which it should focus its attention. First, the first 3 weeks of the second Trump administration has witnessed a more systemic and sustained assault on Congress's constitutional primacy with respect to appropriations and spending than anything we've seen before. It would take more time than I have this morning to list all of the examples, but we're seeing the executive branch repeatedly violate clear statutory spending requirements and prohibitions, whether under the Impoundment Control Act, various statutes setting up and funding the USAID, NIH appropriations riders, or otherwise. The Constitution's unusually clear about appropriations, Mr. Chairman. Contrary to the comments made by Chairman Cole last week, these statutes are all laws that have binding teeth for purposes of the Supremacy Clause. Indeed, uniquely with respect to appropriations, the Constitution expressly requires that Congress play the primary role in federal policymaking. In each of these areas, then, the executive branch is not just breaking the law, it is usurping this body's single most important policymaking power. Second, we've also seen unprecedented efforts by the president to assert control over the entire bureaucracy, and quite overtly to do so in the name of loyalty to the president rather than fidelity to the Constitution. Third, and speaking of unprecedented, we've seen the president use the guise of an office located within the executive branch to take unitary control over virtually all of the federal government spending and personnel management functions, again, apparently in violation of an array of statutes limiting who may have access to those systems and for which purposes. Finally, I'd be remiss in not also noting the various actions this administration has undertaken against private persons that flatly contravene existing statutory and constitutional protections, such as the attempt to narrow the scope of birthright citizenship, a right protected not only by the 14th Amendment, but by a statute Congress enacted in 1940. Other examples abound, but I suspect the point has been made. In 3 weeks, we have seen a more sustained assault by the president on this institution's constitutional prerogatives than we've seen in the first 250 years of our republic. To be sure, we've also seen the federal courts pushing back against these abuses, in many cases aggressively, but the courts can't and shouldn't be expected to go it alone. Some have tried to defend this rash of unlawful behavior on the ground that the executive branch is rooting out fraud and other abuses. Of course, if that were actually the goal, we should have expected some discussion of the Department of Defense. But at a more basic level, this committee and Congress as a whole has spent much of the last 160 years setting up sophisticated, accountable inter-branch mechanisms for holding the executive branch to account in precisely these spaces. It's not like fraud, waste, and abuse became problems only over the last 4 years. That includes inspectors general. It includes DOJ offices designed to root out corruption and others. Rather than lean into those checks, the president's response has been to fire most of the inspectors general, including those he appointed, and the head of the government agency that protects whistleblowers. Maybe there's an argument that this is good policy, I'm skeptical, but that's an argument that should be made to this body in its consideration of new legislation, not through repeated assertions of executive fiat. The result of the executive's assertion of authority and Congress's abdication of responsibility has been not just an unprecedented breakdown in the separation of powers, but a growing and seemingly unending list of negative real-world impacts on everyday people who may no longer have access to experimental medication, who may no longer receive timely storm warnings, who may no longer be able to receive the government-subsidized health care Congress has provided for more than 60 years, and so on. Even farmers who sign contracts with the USDA to be reimbursed for modernizing their infrastructure with guarantees that the federal government would cover part of their costs are now on the hook for expenses they can't afford and projects they can't complete. Everywhere you look, there are stories like this one. This is not just an administrative law crisis, Mr. Chairman, it is a government credibility and credit crisis. Against that backdrop, it strikes me as more than a little ironic that this committee believes the most important thing it can and should be discussing today is whether to enact the legislation being proposed. It seems to me instead that these topics deserve more of our attention, and I would look forward to participating in those discussions. But having this hearing sends exactly the wrong message about the institutional autonomy, constitutional authority, and democratic responsibility of the legislature, the branch of the government that the Constitution quite deliberately put first.
Thank you, Mr. Vladeck. Professor Vladeck. We'll proceed now under the 5-minute rule with some questions. I'm going to recognize myself for 5 minutes. Mr. Smith, according to what you just told us in your testimony, Exxon spent approximately $20 million defending its acquisition of VView against the FTC, which was more than the acquisition price itself, I guess, is the way you described it. But you were willing to spend that money because you believe that every American has the right to due process. So why is due process so important to you as a business owner, having lived through it and experienced it the way you have?
This may seem cliche, but it's more important to me as an American. And I hear the passion in people's voices. There are many things we can disagree on, but I think progress can happen when we can find bedrock principles that we all agree on. The systems of checks and balances, for example, is so critical to a functioning democracy. And what I came to understand with the FTC was, in fact, there is a system that has gotten out of balance, where there is no check and balance, where there is no independent judiciary, where that agency can act as judge, jury, and prosecutor. And they presented me with a situation where they either threatened me to go into court, where there was a 0% chance over 20 years of having a fair trial where I could win, or to effectively seize my company's most valuable assets, give us an unlimited liability, and place all my 4,000 employees and all of our customers at risk. And so that's why I'm here today, as I'm now very passionate about this. I was disappointed when the FTC dropped their case against us because I felt the system was so unfair. I wanted to see it make its way back up to the Supreme Court. But when they dismissed their case, I jumped at the chance to come and testify before Congress today because together we have an opportunity to fix the checks and balance by just simply having independent judges review every case when the government is going after an American.
Very good. Dr. McLaughlin, in a lawsuit challenging the FTC's pre-merger notification rule, business groups claim that the FTC's rule will cost over 7 times the amount that the FTC estimated in its final rule. This is kind of a consistent problem that we see. And the FTC estimates that it will cost billions. The FTC has not articulated how it will use the information to better enforce the antitrust laws. And the FTC has never articulated past examples of missed enforcement that would justify the rule. Is this type of potentially burdensome regulation that Congress, we should sit down and analyze this and potentially act on it?
Thank you. So you're referring to the new HSR rules, of course, and I did take a look at those as a reference point. The paperwork burden estimate from the FTC may indeed be low compared to what other people estimate it to be. I think it's worth pointing out that those estimates, similar to what Mr. Smith is pointing out, are produced by the same people who want to produce the rule. So maybe there's a conflict of interest there. But I would also point out that even though that paperwork burden may be what the FTC estimated or maybe 7 times larger, it still is very small compared to the overall burden of regulation. And that's my main point here. The big burden here is the totality of regulation, much more than any individual rule's consequence.
Right. Let me just follow that up. So the Separation of Powers Restoration Act, or SOPRA, would enshrine the court's rejection of Chevron deference and clarify other deferences that have allowed agencies to act as informal legislative bodies. So, and the key point is probably that SOPRA would require judges to conduct de novo review of agency statutes, the regs, the guidance documents. Can you talk about how enshrining judicial review in law may slow the pace of regulations for administrative agencies?
I think it would end up at least leaving some percentage of rules aside. And it would work like this. Agencies are going to now be aware that there's no deference anymore. No judicial deference of any sort that they can rely upon to push a rule forward. So some percentage of rules will probably just not get pushed forward at all. They will choose not to take that risk of pushing something forward that previously could have stood up because of the different deference documents. What percentage that will be, I don't know.
Yeah, I mean, the delaying factor is built into the system, which could actually, I think, assist Congress in having the time to examine and take a deeper look on some of these things before they simply become law, is the problem, right?
Yeah, and there's going to be plenty of room, hopefully, in different reforms for Congress to play a more active role. And I think that my research in the area has shown it's necessary for another set of minds to be looking at the different analyses and regulations coming out of the agencies.
Thank you. Now recognize the ranking member for 5 minutes.
Thank you, Mr. Chairman. Professor Vladeck, while the Republican majorities in the House and Senate stand aside and do nothing to stop the Trump administration's incursions on congressional authority, the courts have begun to step in and block some of these unlawful actions. But not content merely to undermine congressional authority, in the face of these court decisions, senior administration officials have now tried to question the legitimacy of the courts themselves. For example, in response to a court order blocking Elon Musk from accessing sensitive Treasury Department data, Musk said that the judge who made the ruling, quote, needs to be impeached now. Vice President J.D. Vance stated that, quote, judges aren't allowed to control the executive's legitimate power. President Trump said, quote, no judge should frankly be allowed to make that kind of decision. It's a disgrace. The White House called the judgment absurd and judicial overreach. And now these vague threats to judicial independence have seemingly crossed the line into actual defiance of a court order. Yesterday, a federal judge in Rhode Island ruled that the White House had defied his order to unfreeze billions of dollars in federal grants. Can you describe the constitutional crisis we would face if the Trump administration continues to ignore valid court orders?
Sure. I think, Congressman, we've never seen a crisis quite of that scope. I mean, the famous quote about Andrew Jackson and John Marshall is apocryphal. Andrew Jackson actually did not frustrate the Supreme Court's decision in Worcester versus Georgia. The only example we have of a president ever openly defying a decision by a justice was Lincoln at the outset of the Civil War, refusing to comply with the writ of habeas corpus issued by Chief Justice Taney by himself, not by the full Supreme Court. We've never seen a president who said, okay, the Supreme Court has told me I have to stop doing something, I'm gonna keep doing it. And I think the critical point at that point is we would have a breakdown, Congressman, not just in the rule of law and the separation of powers, we'd have a breakdown in the courts because the executive branch depends upon the courts when it's the plaintiff to prosecute crimes, to bring civil enforcement action. So I think, the point of no return would be a point when the courts are no longer willing to even do the executive branch's regular business because the executive branch won't abide by the court's judgments.
In your testimony, you briefly described 4 areas that this committee should be focusing on right now to address the unprecedented power grab by President Trump and Elon Musk, or maybe I should put that in reverse order. Can you please elaborate on these suggestions?
Sure. I mean, it seems to me that this committee, both historically and currently, has both the power and the mandate to engage in rigorous oversight of what the Department of Justice specifically is doing, of how the executive branch is complying or not complying with the various statutes, of the firings of inspectors general, of the firing of the special counsel Hampton Dellinger, who is the the head of the whistleblowing agency within the federal government. This committee has the power, of course, to consider whether legislation should be proposed, to rein in some of these claims, to backstop existing statutes, or perhaps even if the majority is so inclined to authorize what the president is doing. But the point, I think, Congressman, is that what we have seen over the first 3 weeks is the president suggesting that this committee and all of Congress is completely unnecessary for him to do what he wants to do. And so whether it's through oversight hearings, whether it's through withholding legislation, whether it's through passing legislation, whether it's through the bully pulpit that members of this committee on both sides are so skilled at using, it seems like there is a much more important story to tell about what is happening right now to the separation of powers in this country than the admittedly important stories of my fellow witnesses. Those are all problems, but what we're seeing is a structural attempt to reallocate power, the likes of which we've never seen before, and that's where I think this committee has a responsibility.
Mr. Smith has argued for an independent judiciary. If we allow the Trump administration to skirt court orders, does the independent judiciary really function?
So I guess I am one congressman who still thinks that the line is holding. We have more examples historically of what I would call slow-walking compliance with court orders by the executive branch, the likes of which seems to be happening right now. I would not put it past the possibility, Congressman, that part of the lack of compliance we're seeing is because of incompetence, not malice. And so it seems to me that we are not at the point yet where the executive branch is affirmatively refusing to comply with federal court orders.
And if we get to that point?
Then I think it would be incumbent upon this committee to pursue articles of impeachment. And I would hope that there would be sufficient members of the majority who would think that that was part of their constitutional responsibility, that the politics of the moment would give way to the politics of our constitutional order.
Thank you, Mr. Chairman. Mr. Chairman, I yield back.
Gentleman's time is expired.
Thank you, Professor. Mr. Chairman, I yield back.
Gentleman's time has expired. Now recognize the gentlewoman from Wyoming for 5 minutes.
Thank you. I guess I would take your testimony a bit more seriously, Mr. Vladeck, if you actually had ever complained or shown any light on the Biden administration's efforts to forgive the student loans in violation of the law and court order. Ms. Wade, I appreciate your passion for this issue. It is something that is incredibly significant, and I think the caterwauling that you hear on the other side is what happens when you shine a light on the scurry little things that live under most rocks that most of us find rather disgusting. The 2024 version of CEI's 10,000 Commandments found that federal regulations' total compliance costs and economic effects are at least $2.117 trillion annually. U.S. households pay an average of $15,788,000 annually in a hidden tax, which consumes 17% of income and 22% of household expenses. The Biden-Harris administration imposed over $1.7 trillion in cumulative regulatory costs on the economy, surpassing all predecessors. The issue of overregulation in this country is absolutely real, and it is people like you that are affected, regardless of whether Mr. Vladeck feels that you should have a voice in these proceedings. Mr. Smith, I want to turn to you because I think people need to understand what ALJs, administrative law judges, and administrative law courts actually do in this system. If you want to talk about unconstitutionality, Article 3 establishes an independent judiciary to protect citizens from loss of life, liberty, and property without due process of law. Over the last 50 years or so, a variety of federal agencies have created their own court systems, led by administrative law judges. It would come as no surprise to no one that agencies enjoy outsized success in proceedings before these ALJs. After all, they're wearing the same jerseys. They're on the same team. In Article 3 courts, as provided by the Constitution, the SEC only wins about 58% of its cases. And between fiscal year 2011 and 2014, the SEC, however, won an average of 90% of its cases in front of ALJs. The FTC, who you went up against, wins not over 90% of its cases before its own ALJs. Yet Lena Khan, who was the head of the FTC under the last administration, lost almost every single case she ever brought before an Article 3 case, or an Article 3 court. When Axon was forced into the FTC Administrative Law Court, or ALC, proceedings, were you provided with the same protections and rights you would expect in an Article 3 court, such as due process, the right to a trial by jury, that sort of thing?
Absolutely not. No, it was a foregone conclusion. Frankly, it was described to me by my attorneys as hopeless. There was a 0% chance over the previous 20 years of getting a fair trial. And even once we came out, if it went to appeal, the appellate process would be only reviewing the FTC's version of events. They get to write the entire record, and you never get a day in court. Maybe you get an appellate review to see if they made an error in the law, but we would never have gotten a chance for an independent arbiter to hear our claims.
I would think that the people on the other side and Mr. Vladek would be concerned about the violation of constitutional rights that you just described, but apparently they're more concerned about protecting the unelected bureaucrats and their ability to send millions of dollars to things that we don't want to pay for, such as trans comic books for people in Peru. The FTC enjoys over 90% success rate in proceedings before the ALJs, as we just talked about. And what I understand is that you were forced to spend $20 million defending yourself in these FTC proceedings. Having been an administrative law attorney for many years, I describe this as the process is the punishment. Would you agree?
The process was a heck of a lot of punishment. However, it was nowhere near what was being threatened. I mean, for a $13 million acquisition, the government was basically looking to seize $1 billion worth of intellectual property, as well as half our customers, and an unlimited liability. So the process was terrible, but we had to go through it because the alternative was even worse.
As you likely know, in this Congress, I have introduced the Seventh Amendment Restoration Act, which provides Americans with the right to remove their cases before an ALJ to an Article III district court. Do you think that that is something that would have helped you in pushing back and fighting back against the FTC in these horrific proceedings?
I have to say that that proposal is beautiful in its simplicity, and I think it actually would fit what we've all talked about, the system of checks and balances functioning properly, that an American should be able to say, my goodness, if I have the government coming after me, may I please have an independent judge where I can plead my case and have a chance of prevailing.
Thank you, Mr. Smith. Thank you, Ms. Wade. Thank you, Dr. McLaughlin, for being willing to come here and expose this horrific situation, this horrific administrative situation that we're dealing with. I yield back.
Gentlewoman yields back. We now recognize the gentleman from Maryland, the ranking member of the full committee, Mr. Raskin.
Thank you, Mr. Chairman. In just the last 22 days, which seems at this point like 22 months, they've sacked 17 inspector generals, the major corruption fighters in federal agencies. They've illegally tried to freeze government spending that has been appropriated by the Congress of the United States. They've fired heads of 4 independent agencies, and they've shut down work completely, at least 4 agencies, paying thousands and thousands of federal workers to do nothing because they want to try to bring the work of the federal government that doesn't directly profit them to a screeching halt. Meanwhile, Musk and his completely unvetted and untrained night crew of assistants have gained access to at least 18 federal agencies, stolen reams of the American people's data from the agencies, and fired thousands of workers in violation of civil service due process, trampling all of the checks and balances and rights to individual adjudication that Mr. Smith just referred to. All of these actions are profoundly disturbing, but it's the data grab that is rocking the American people right now. The capture of this data represents an unprecedented hack into our most sensitive information and a profound risk it is for all Americans. Professor Vladek, Musk and his team say that they access these sensitive and confidential data sets, some of them might include classified information for all we know, in order to root out fraud. How do we actually root out fraud in the government?
So historically, Congressman, as you know, the way that we root out fraud is through a series of overlapping and interlocking mechanisms. The inspectors general are the first line of defense within the agencies. The idea is that their job is to provide regular audits of what the agency is doing. As you know, there are various statutes that allow private citizens to seek to investigate fraud and to make claims against the government when they think there is fraud. The False Claims Act at the top of that list. And then, Congressman, there's this committee, and there's its companion committee in the Senate that use its oversight functions to ensure that the government is complying with its statutory obligations. Its obligations, Congressman, to investigate fraud in all of its spaces.
Well, to illegally wipe out all these inspectors general, and it was in direct and admitted violation of the federal statute, which says that the president has to come to Congress first and set forth the rationale for why they're being fired 30 days before it happens. But in doing that, what will the effect be on actually trying to root out waste, corruption, fraud, self-dealing in the agencies?
So I think the reality is that you're going to have a split between fraud, waste, and corruption that has no coordination, that has no involvement from senior officials in the agency, which I suspect the agencies might still have some interest in going after, and fraud, waste, corruption, and abuse that the senior officials in the agency are aware of because now they're the only people in a position to do anything about it. The reason why Congress historically separated the function of the heads of agencies from the Inspector General is so that the Inspector General would be in a position to review even the senior leadership of agencies when it came to these concerns. That's the biggest thing you lose when you fire all
right, so if they're undermining the infrastructure that's set up to actually try to target fraud and waste and abuse, why are they accessing all of the data of the American people?
I mean, I think that's a question this committee ought to ask them, Congressman. But I'll just say, and I think this is an important point, we can all surely agree that rooting out fraud, waste, and abuse in the executive branch is actually a noble goal, and it's a goal that we should all be invested in. But the way to do it is to either, one, use existing mechanisms, or two, come to this body, Congress, this committee, and suggest why the existing mechanisms need to be reformed, as opposed to starting from scratch.
Well, Elon Musk is the wealthiest person on earth, or at least he was before the collapse of Tesla in Europe recently, but he's a very wealthy man. Could he benefit financially from accessing all of the data in the United States Department of Treasury computers?
I mean, I would think anyone who has contracts with the United States and with other governments would benefit from having access to that information.
A federal judge in New York just ordered Musk to destroy the data they had illegally obtained from the Treasury Department. This is the judge they're all now talking about impeaching. Who can ensure that Musk has followed the order of the court and destroyed this data?
I mean, it seems to me that there are two possibilities, Congressman. The courts are first, and I think Congress and this committee in particular are second.
We're reading reports that Musk has fed Americans' data, private data, into AI models. And he's also making a bid for another company in artificial intelligence, just going ahead and doing his business while he's purporting to do the business of the American people. What dangers are posed by the feeding of our data into an AI system, if that were to happen?
I mean, I think there are multiple levels of danger, and I know that the time is expiring. I'll just say that I think the most obvious dangers are the possibility that this data will become accessible, not just to our government operations, but to our enemies overseas, and they'll use that for malicious purposes.
Gentleman's time has expired. Now I'll recognize the gentleman from North Carolina, Mr. Harris, for 5 minutes.
Thank you, Mr. Chairman, and thank all of you on the panel for sharing today. I want to speak to Ms. Wad for just a moment. In your testimony, you explained how the regulations in New York and California made it difficult for your businesses to flourish, so you moved to Austin, Texas. Just want to give you an opportunity, and I appreciate you coming and sharing today. Was there a specific moment when you realized you needed to move your business to a more business-friendly state?
Thank you for the opportunity. Yes, it started when I was in California, because first I was in California, then New York, then Austin. It started when I was in California, and when the cost of, and you see, this is where, when people ask, what was it a special thing? It was not a special thing. You know, it's one of those things, it's death by 1,000 cuts, literally. I mean, what people don't realize is we've got millions and millions and millions of lines of code. Each law, each regulation is a line of code. And to be compliant, it's almost impossible. I know that every day I'm probably violating the, you know, the 3 violations a day thing that people talk about. I know. And if I had some opponents, they could look easily into my 4 businesses or the nonprofits that I have, and they will find something. Not because I was being facetious, not because I wanted to be against the law, but because the law is so darn complicated that you're bound to make mistakes, even if you have lawyers and attorneys. It happens all the time. So at some point, after going through California, I eventually went to New York. New York was no better. Actually, I would argue, it was definitely no better. And I had to look around and really now take it seriously, the ranking of the most free states in the country. And eventually, that's when how I landed in Austin, in Texas, literally.
Well, although you have 50 state regulatory environments to choose from, you're still subject to the federal regulations wherever you go in the United States. And despite the improvements in your business since the move to Austin, what challenges would you share with us still persist even at the federal level?
Again, I get that question even about Africa. What would you address? And I'd say to people, by now, things have gotten so bad, Representative, that if you want to hear the truth from me, I believe that the best thing that it's not so, for me, it's no longer about talking about what the Fed has done wrong. It's about talking about what could they do right going forward. And going forward, I would argue that the House is so, the foundation of the House is so rotten. The founding fathers really were going for competitive jurisdictions. And, we've been eating away at that. And now there's cumbersomeness everywhere. So much that the easiest and best thing to do for Congress would be these zones that we call them, in my case, Prospera zones, that is what I'm doing in Africa. Because in Africa, we have a worse case situation than even the US. And the best way to do this is to basically, at the federal level, can we find zones where we apply a general repealer, basically repeal all the commercial laws and have a chance to start fresh. That's really what I'm advocating for at the federal level in the United States today. So let us create these zones where we can actually start fresh and create areas where we have new miracles of growth that can happen. Now let Texas compete with these zones. I think it's going to be the fastest way to clean things up, because otherwise we're just going to be sitting here in these circles complaining all day long about this law here, that law here, which I would argue does nothing. So at this point, we've got to be radical, we've got to be bold, because if something is not done quickly, radically, I'm afraid, Mr. Raskin, soon you're not going to have the United States of America to speak of. The only reason why we speak of the United States of America anywhere is because of the power of the U.S. Power of the U.S. because of economic power of the U.S. If the U.S. keep going down this path of overregulation, this country will be poor, and poor nations have no say. So that would be what I recommend. If we continue down this path, if we don't do anything, this country might not be spoken about in a few years.
Unfortunately, our government today is a far cry from what our founders intended. And today, unelected bureaucrats are some of the biggest spenders in Washington, and Congress has got to take back the power of the purse through common sense regulatory reforms. The REINS Act requires congressional approval of any federal agency rule with an impact of $100 million or more before they take effect. Dr. McLaughlin, I want to ask you, in your view, would implementing the REINS Act bring Congress more in line with what the drafters of the Constitution intended?
Yes, it would. Ultimately, regulations stem from congressional authority, and the REINS Act lines up with that line of thinking.
And in your research and a lot of things you've spoken about the economic impact of federal regulations, let me just ask, what effects on the economy would the REINS Act bring if it were to become law?
I think it'd be subtle. I think some of the threats of using the REINS Act would be more effective than actually using it. When agencies are aware that the REINS Act can be used, I think they'll act differently.
Thank you very much.
Gentleman's time has expired. Gentleman from California, Mr. Correas.
I want to thank you, Mr. Chairman. I especially want to thank our witnesses for being here today. Appreciate your testimony today. And I only have 5 minutes, so I'll try to be quick. Start out with Mr. Smith. I want to ask you a yes or no question, sir. The FTC started its investigation into your acquisition of Evenue in 2018. Was that case started by the FTC under the Trump administration? The answer would be
embarrassingly, yes.
Yes.
Sorry, I was trying
Thank
to do
you.
the
It's a
math.
yes, no. Thank you. And Ms. Wade, I'm going to agree with you. Back home, my neighbors in Orange County, they don't really care about the details of regulation. All they want to know is our water safe to drink? Are cars safe to drive? Are medications safe to take? And are our children safe at school? And of course, is the air they breathe, is it clean and safe? This is a picture of Los Angeles back in the 60s and 70s. Regulations made this air in Los Angeles, Orange County, much cleaner. I was a kid then, and I can tell you, trying to play out in the playground in those times was painful. Literally, you had to stop playing because your chest would hurt, all of us. Regulations, some are good, some are really good.
May I say something to that, please?
No, ma'am, it's
Okay.
my time.
I wanted
The
to be
Supreme
noted, but I
Court-
wanted to say
ma'am,
something and you said no.
Ma'am,
Thank you.
you got other people that may ask you a question. Thank you. The Supreme Court, when it comes to regulations, have made things worse. And members of Congress are willing to go along with the president, essentially giving up more of our express authority to the president. Are there cases of overregulation? Absolutely. But full-on deregulation is not the answer. It'll probably create more havoc, uncertainty for businesses, and imperil the health and safety of many Americans. Mr. Vladeck, U.S. government civil servants take an oath of loyalty to the Constitution and the United States. Does this oath of loyalty apply to all civil servants, including CIA, FBI, food inspectors, immigration frontliners, Social Security, and Medicare employees?
Everyone.
These civil servants could be making much more money in the private sector, yet they work for the federal government because they believe in the mission and helping citizens and small business in this great country. Please tell us what this oath of office means in the context of how civil servants should be carrying out their duty.
Well, I think, Congressman, for generations, it is meant, for better or for worse, that civil servants don't work for the president, they work for the government. And that the mission is to do what is in the best interest of the Constitution of the United States, not the best interest of the current holder of the chief executive office. We won't always agree about how those civil servants carry out those missions. We won't always agree about what it means to be faithful to the Constitution. But the mere agreement that that is the goal, the mere agreement that that is what
oath and loyalty to the United States.
And, you know, we're all going to have different visions of what that is, Congressman, but at least we all agreed that was the purpose.
Professor Vladeck, let me cut you off. In your testimony, you said, quote unquote, paraphrased, in 3 weeks, I've seen a more sustained assault by the president on this institutional's constitutional prerogatives than we've seen in the first 250 years of this republic. Please elaborate. That's a very strong statement.
It is, Congressman. It's not one I make lightly, and it's not one I wish we were in a position to have to even be discussing today. But, you know, when I look at how much power the president is claiming to not spend money that the Congress has appropriated, to defy statutory limits that Congress has imposed, to fire officials who Congress has insulated from removal, to take control of the bureaucracy in ways that politicize everything down to line attorneys in the Department of Justice, we've never seen, we might have seen flashpoints of that, Congressman.
Professor
we've never seen all
Vladeck,
of this together.
Everybody talks about inspector generals. For my folks back home, can you explain to us what an inspector general does?
So an inspector general is a government officer who's meant to look inwards at the agency of which he or she is the inspector general, and is meant to ensure that the agency is not engaged in fraud, waste, or abuse. They can do that on their own prerogative. They can do that at the request of employees. They can do that at the request of outsiders.
So if they're fired, what's the message here?
I think the message is that we don't want someone looking that carefully at what we're doing.
Thank you very much, Mr. Chairman. And I'm out of time, but if I can, I'd like to ask unanimous consent to have the following documents entered into the record.
Granted.
The article from the New York Times called "Trump's Actions Have Created a Constitutional Crisis," scholars say. Second, pro-Republica article, "Do regulators really kill jobs overall? Not so much." Third article, release from Rutgers University, "Federal regulations don't really affect economic growth." And the fourth, from the Columbia Climate School, "The Dangers of Deregulation." Thank you.
Granted without objection.
Mr. Chairman, I have one UC request too, if it's okay. This
Gentleman's
is
recognized, yep.
an article from The Economist last year, October 2024. "The envy of the world, the American economy has left other rich countries in the dust." Cover story. Thank you.
Granted without objection. We'll now recognize the gentleman from California, Mr. Issa, for 5 minutes.
Thank you, and I really appreciate the testimony of my colleague from California, since it looked like it was testimony and nothing more. You know, the interesting thing is that that oath he talked about, every state employee in California takes a similar oath. And the odd thing is the district attorneys take an oath to the California Constitution and the United States Constitution, which means that they understand that sanctuary city law is unconstitutional, that it's wrong, and that interfering with federal employees trying to execute, in fact, would be a conflict of their oath. So I know the gentleman means well, but, you know, people sign oaths. How many take it seriously? And the answer is not nearly enough of our federal employees. Just yesterday, we dealt with the recognition that some people at the FBI, either agents or staff, had willfully disclosed ICE's actions in a way that could cause them to be shot or killed by the MS-13 people they were attempting to round up as both criminals and illegal immigrants. Oaths are a wonderful thing, but with all due respect to my colleague who's left the room, let's talk about faithfully executing the Constitution. Mr. Smith, on the subject that we're here for, are you aware that the Federal Trade Commission has nearly a 100% success rate in their administrative court?
Yes, certainly.
Are you aware that even if an administrative judge were to not find you guilty, so to speak, that the commission can overrule that and basically make you guilty?
Yes, and I believe they do almost all the time.
Are you aware under the last 4 years of the Federal Trade Commission, they had far less than a 50% chance of surviving if they went to a federal court with a judge and a normal process of due process?
I believe that.
So the reality is you've got a kangaroo court at the Federal Trade Commission, and with all due respect, it doesn't really matter who's in the White House. The Federal Trade Commission has asserted its authority far beyond the intent of Congress.
I agree.
Now, in your case, you struck a chord with the Supreme Court. Basically, the recognition that when they start getting into constitutional issues, they don't have that right, period, that the Article III judges do have that right, and you don't have to exhaust all of the kangaroo court procedures before getting to the Article III court. Is that true?
It is, yes.
But let's ask the question for you and the others here. Wouldn't we be better off if, knowing that the Federal Trade Commission is not faithfully executing the intent of Congress, the statutes, and the Constitution, that you didn't have to wait and spend millions of dollars and perhaps lose an acquisition, and you were simply able to go to where you have a right, which is the Article III judges themselves, if it's a federal law?
100%, yes.
Here's the last question, and I'd like each of you to opine on it briefly. The REINS Act attempts to say for major regulations, is there any reason that any of you can find that Congress should not be able to, at any time, by a simple vote, second guess, in other words, second guess a regulation that has been made by an agency that says it's the will of Congress, but in fact cannot substantiate that it is? And bearing in mind, the same numbers that it takes to pass a law are the same numbers it takes to object to a regulation. You, Mr. Smith, first.
Seems reasonable.
Ms. Wade?
Likewise, seems reasonable.
Doctor?
Yes.
Give you a shot.
Absolutely. The REINS Act, yes, I agree.
Yes, sir.
I mean, I think there's a longer conversation to have, Congressman, about legislative vetoes after INS versus Chadha. I think, one of the things that I'm struck by is I don't know.
Well, wait a second. I was asking a more narrow question than a legislative veto. If, in fact, regulations were considered by Congress de novo, and they simply said, will we support that regulation? It's not a veto if you ask, is that regulation consistent with Congress? And you go through the process of the House, the Senate, and the White House. Is there anything inherently wrong with that?
I'm sorry, Congressman, I misunderstood. I thought you were skipping presentment. No, of course, Congress can do anything to overturn a regulation through bicameralism presentment.
Okay,
I wish Congress would do it more.
Right. And now, Doctor, I'm going to close with this very briefly. If, in fact, Congress doesn't have the will to sustain a regulation, effectively holding a vote and not getting a majority would be the equivalent of saying we don't want that law. Isn't that correct?
That does sound correct, yes, sir.
Thank you. I yield back.
Gentleman yields back. Now recognize the gentleman from Illinois, Mr. Garcia, for 5 minutes.
Thank you, Chairman Fitzgerald. And what we're experiencing right now is a 5-alarm fire of the administrative state, and not for the reasons that my colleagues across the aisle are saying. Instead, In the first few weeks he's been president, Trump and his pal Elon, an unelected bureaucrat, are bulldozing key watchdog agencies. Instead of protecting people from government overreach, they're destroying the mechanisms to protect them. As it turns out, their approach is so unpopular with the American people that they've had to save face a couple times by pretending to abandon course. That happened with the government funding freeze. What people want is for corporations to be held accountable, not for their Medicaid benefits to disappear, then used to fund tax cuts for the ultra-wealthy. What my constituents want is for their civil rights and liberties to be respected, not Elon Musk's teenage fanboys prying into their personal information. What their actions prove is that DOGE isn't about efficiency of the administrative state or for the American people. Instead, it's about allowing corporations to abuse workers with fewer rules and ripping off consumers with more impunity than they already do. Take the National Labor Relations Board. Since the Great Depression, the NLRB has a proud history of protecting the rights of employees to bargain collectively. In fact, the NLRB has repeatedly ruled against Tesla for violating labor laws, including retaliating against workers for union organizing and focusing employees to delete pro-union tweets. But on January 27th, the Trump administration made the unprecedented decision to illegally fire NLRB board member Gwen Wilcox. Federal law states that the NLRB members may be removed for neglect of duty or malfeasance in office, but no other case. Yet, neither was cited as the basis for Ms. Wilcox's firing. So, my first question for Professor Vladeck. Based on your legal expertise, how does this action violate statutory protections for independent agency members, and what does it mean for American workers?
I mean, I think it's pretty clear that it violates the statute, Congressman. I think the question that's going to arise in litigation is arguments that that statute's unconstitutional, but we're not there yet. I mean, the courts haven't said as much. What does that mean? I mean, I think it means that you lose the capacity, even in this administration, to have meaningful enforcement through the NLRB and through its processes of our federal labor laws, which, of course, I think tilts the scales in one direction toward the folks who are alleged to have violated those laws.
Thank you. Moving on to the CFPB. It's an independent agency created to protect consumers from predatory financial practices, including hidden fees and data privacy violations. It's won back $17.5 billion for Americans since its creation in 2008. In just 2 weeks before Trump took over, the CFPB sued Capital One for cheating people out of interest payments, ordered a major auto lender to return $10 million to customers, and ordered Cash App to refund $120 million to customers. Predictably, billionaires who want to get rich off of predatory practices don't love this agency. And as of this weekend, Trump and his cronies shut it down. Professor Vladeck, from a legal perspective, can you explain the importance of independent agencies like the CFPB, which has a statutory mandate to protect consumers, and when they're eliminated, who gets hurt?
So, I mean, I think for over a century, Congressman, Congress's position has been, and I think it's been borne out, that independent agencies and independent commissions are better situated to look out for things like, the securities market, to look out for things like consumer protection, than presidents of political parties who have, donors, political allies to try to support. Who gets hurt? I think the folks who get left in the balance are the folks who don't have access to the White House, the folks who don't have the ability to persuade this president that it's in his interest to support them. And I think that's increasingly the members of the American working class, Congressmen, Democrats, and Republicans alike.
Thank you, sir. And finally, Mr. Chairman, I ask unanimous consent to enter into the record an article from Foreign Policy dated January 24, 2024. that reports that the economic zones, which have been referenced by one of our witnesses today, and she was just celebrating, were found to have no transparency or accountability mechanisms, bear an astonishing level of autonomy, which the UN has expressed concern for human rights. They have created private courts, private police forces, and privatized law systems, which have no place anywhere in the world, and certainly not in the U.S.
Granted, without objection.
Thank you, sir. The title is U.S. Investors Could Bankrupt Honduras with Biden Administration Support. I yield back.
Gentleman yields back. Gentleman from Kansas, Mr. Schmidt, is now recognized for 5 minutes.
Thank you, Mr. Chairman. I want to thank all the witnesses for being here and for their patience. We have heard a lot of words today. I marked these, Ms. Wad, when you said them the first time through. I think perhaps the most important words we've heard today were in your prepared testimony. You said, "I'm here to provide a sense of urgency regarding the need for streamlined regulatory and administrative rules." And then you said, "Large, powerful firms can afford armies of lawyers and attorneys to stay compliant. Smaller entities do their best and try not to slip up." Mr. Chairman, that is what this hearing is about, and I want to thank you for calling this today. Look, this stuff can get mind-numbingly dull, especially when you get into the academic literature surrounding administrative law. But there's a fairly new book out. It's in plain English. It's not aimed at an academic audience. I don't know if our witnesses have had a chance yet to read Justice Gorsuch's new book, Overruled: The Human Toll of Too Much Law. I see Mr. Vladeck has a chuckle. Apparently he thinks the justice is insufficiently brilliant on this subject matter. I have a different point of view. One of the things that appears in that book is a chart drawn from the Regulatory Studies Center at George Washington University. I've asked the staff to place it on the screens for us. This is the chart of the number of pages in the Federal Register starting in 1950. Take a look at that chart. It's a zero-based chart. It's not cutting off the top. It's about 10,000 pages of regulatory law in the United States in 1950. The year I was born, 1968, it had exploded after the Great Society to about 50,000 pages. It is today pushing 200,000 pages of binding regulatory law. Mr. Chairman, that is why the folks I represent in Kansas sound a whole lot more like Ms. Wad and Mr. Smith than they do like Professor Vladeck or some of my colleagues on this committee. They're not worried about the academic impact and the theory. They're worried about what it means for their day-to-day lives, and can they stay compliant, and can they continue to operate, and can they pursue the American dream? So I have a couple of questions for our witnesses. Let me start with Mr. Smith. Mr. Smith, as Kansas Attorney General, I took a number of cases all the way to the U.S. Supreme Court challenging various federal regulatory actions. I know how burdensome it can be. I'm thinking of one when we challenged an Obama-era iteration of the Waters of the U.S. rule. We started in district court in Georgia. We ended up MDL, and I think it was Ohio, fighting about whether we'd started in the right court. We had to await a U.S. Supreme Court decision on the jurisdiction issue. We went back to Georgia after that all happened. We finally got an injunction, and the administration appealed, and then we were 3 presidents later before the political system finally overtook the litigation. You talked about how much money you spent fighting your one battle. Could you have used that money more effectively in some other manner?
Oh, goodness, yes. I mean, we could have put it into research and development, building new products, innovating, entering new markets with sales investments, lots of places that would have had a return for our investors.
Did the regulators pay your attorney's fees when that was all over?
No, sir, they did not.
I see. And Dr. McLaughlin, let me ask you this. I was intrigued by my colleague, Congressman Iss's line of questioning. I was especially intrigued when he went down the panel, and I believe all 4 of our witnesses agreed, Professor Vladeck enthusiastically, if I'm not mistaken. I don't want to mischaracterize it, but as long as there's bicameralism and presentment, I think your words were you would like to see Congress do more of overseeing and deciding whether to keep particular regulations. So my question for you, Dr. McLaughlin, is this. The Congressional Review Act currently has what is functionally a fixed look-back window. Right now, I think if it's a regulation came in around August of last year or later, we can use the CRA's mechanisms to decide whether we want to keep it or reject it as an elected body exercising the Article I power that is ultimately the basis for the regulatory action in the first place. Is there any reason we ought to limit ourselves to this functionally 6-ish month look back? We got a bill on the floor this week that would make it a year look back. Would that be better?
There's no reason not to extend the look back, in my opinion. Extending the CRA would allow more, we're talking about midnight regulations effectively that the CRA.
But we don't have to be, right? I mean, why are we worried only about midnight? I think it's great to be worried about midnight, but why not 6 p.m.? Why aren't we worried about a regulation that was promulgated in 1994 if it no longer makes sense? And you have bicameralism and presentment, and this body wants to reject that regulation, or in 1958, or in 1973. What's the rationale?
I don't think there is a rationale for not extending it further back. I think that we're just stuck in a situation of inertia.
We've always done it this way. Would you encourage us to take a look at amending the Congressional Review Act to give this body the authority under its procedures to reject agency regulations regardless of when they were promulgated?
Well, as a scholar, I'm hesitant to endorse any specific bill, but it does seem like it would have positive economic consequences.
Thank you very much, Mr. Chairman. Thank you.
Gentleman yields back. Now recognize the chairman of the full committee, Mr. Jordan, for 5 minutes.
Thank you, Mr. Chairman. Ms. Wade was making this point earlier. I thought it was well stated, talking in a broad sense. To lead the world diplomatically, to lead the world militarily, you first have to lead the world economically. And to lead the world economically, you need some basic things. You need readily available energy at affordable cost, and you need freedom. That's Mrs. Wade's point. And you know what? We had a lot more freedom when that chart that Mr. Smith just put up there was a lot lower in regulations, which would help people like Ms. Wade and Mr. Smith, the entrepreneurs who make our economy go and go and go, be able to do their thing. Ms. Wade, you wanted to respond to one of the Democrats. I forget who was asking or saying something. You wanted to respond. I'm going to give you a chance to respond, then I'm going to go to our economists and to Mr. Smith. Hit your microphone, because.
Can you hear me?
Yeah, we got you.
Thank you so much. I want to respond 2 things. Mr. Garcia is gone, but I wish he was here, and same with Mr. Correa, I think it was. So I'll start with Mr. Garcia when he brought up, oh, these Prospera, these zones, she wasn't here, no space for them here in America. Well, guess what? It is going to happen in America. And that article that you brought up, you know, foreign policy, I just would like, the same way that article is going to be included, I would like for the FAQ that I'm going to send you to be included in there as well, so we can refute all those claims that are made in articles like that. If anything, these zones were put in place by the government of Honduras itself in this situation. Government of Honduras. And if anything, we know by now that organizations like the USAID, funding NGOs, have been actually undermining these type of initiatives because these are anti-business NGOs. So USAID hurting us, there you go. And then Mr. Correa, who is not here, I wish he was here when he had the nerves to tell us that these regulations are here to help us. I just would like for him to answer me to this situation. Around the 1800s, since the 1800s, it was known that lead pipes that were being used for, that we were using were toxic, bad, causing probably brain damages in children. As early as 1800, it was known. Then you tell me why is it that it took until 1986 for it to be taken care of. In the meantime, you had the mayor of Chicago who made it mandatory for builders to use lead pipes for the water pipes. Where did government really help us here? Where? I wish Mr. Correa was here. Government is helping us, these regulations are helping us, give me a break. And I see you looking at each other like this, I will send you my report on this, Mr. Raskin. So thank you so much for giving me that opportunity to respond, because it irks me when I see us sitting in these rooms and when I hear your fights. I don't hear government working for the people. I see government working for government, whatever the heck that sounds like, okay? And I would like, for one, that it is about my safety and about my well-being. And in situations like this, and in as many others like that, it is clear that these regulations are not put in place with us in mind, and that needs to stop. And the fact that, Mr. Raskin, you're here this whole time we've been here, you've just been complaining about the process. I'll call it a process. And again, I'm not disagreeing with your issues right now around Musk and the process that's following Mr. Vladek, the process that you're following. At some point, what is the end game? Isn't the end game to make us, the American people, better off? Isn't it? Isn't it? No, I hear you saying that the stuff that would make us better off doesn't matter. All you care about right now is a process of Musk and his associates are not doing this the right way. the goal, is the goal moral and right or not? If you say it is, as I think you should be saying, then the fight shouldn't be about, we need to take Musk down or Trump down. Let us rethink that if you want, but keep your eye on the ball, and your ball should be me. It should be me. I'm sorry, it should be me.
Yeah.
It should be me. How do we make me better off? Thank you,
and by-
Mr. Jordan.
You bet, and by me, you mean the American people.
That's what I mean by that.
Dr. McLaughlin, and we appreciate that. Dr. McLaughlin, in college, I majored in wrestling, but you're supposed to get a degree in college, so I got one in economics. And one of the terms I remember was this term called opportunity cost. Can you tell us real quick what opportunity cost is?
It's the things you don't do because something else requires your
It
resources.
was Mr. Smith spending millions of dollars
Right,
fighting some
exactly.
stupid bureaucrat regulation where if he fought it there, he'd have to go, the very bureaucrats who made the rule and tell him to do things, he'd have to go to their court, and he had to go to other court, and he could have been expanding our economy, building his business, but no.
Perfect.
He had to deal with the bureaucrats who the other side thinks are the experts and should run our government. Isn't that what opportunity cost? When you boil it all down, that's what Mr. Smith had to deal with. Is that right?
Yes, sir, and that's what my research finds, is when businesses get deflected from investing in R&D and expansion, that the economy does not grow, and it's because regulations are making them spend their
Which
resources
makes
on
it
other
tougher
activities.
for our country to lead, to Ms. Wade's point. If you're making it tougher for the people who grow our economy, make us stay the economic superpower, it's tougher then to lead militarily, diplomatically, and that's what it all does. And that's what the chairman, why he's having this hearing, that's what he's trying to change. And we got a bill on the floor tomorrow. Midnight rules bill gets rid of a bunch of these stupid rules that these agencies do. We can get rid of packages of them instead of one at a time. That's a good thing. I appreciate the chairman's work on this committee, and I yield back.
Chairman yields back. That concludes today's hearing. We thank our witnesses for appearing before the committee today without objection. All members will have 5 legislative days to submit additional written questions for the witnesses and additional materials for the record. Without objection, the hearing is adjourned.